I think we can go ahead and get started. Thank you, everyone, for joining us for today's webinar. We're honored to have you with us, as well as our August panel, who I will introduce shortly. My name is Eric Hinton, and I'm the director of the Rowling Center for Business Law and Leadership at SMU Dedman School of Law. And I encourage you to check out our center online or on social media. We're focused on the intersection of business law and leadership. And today's panel and discussion is no exception to that. And we pride ourselves in the faculty that we have here at SMU Dedman School of Law, including especially Professor Steinberg and the thought leadership that he provides. And we're also honored to have our panelists with us today. So as I mentioned, the focus of today's discussion will be the book that Professor Steinberg has recently published, Rethinking Securities Law, which is published by the Oxford University Press. It was awarded winner of the Best Law Book of 2021 by the American Book Fest, and will add is available for purchase at the Oxford University Press as well as on Amazon. As you know, Professor Steinberg is the Rupert and Lillian Radford Chair in Law and Professor of Law here at the SMU Dedman School of Law, and a renowned expert in securities law. In today's panel, we're honored to have the following experts in securities regulation, and we're looking forward to their comments. We have the Honorable Harvey Pitt, former chairman of the SEC and CEO of Kalorama Partners, LLC and Kalorama Legal Services. We have Mr. Alan Dye, who is the co-author of the seminal treatise on Section 16 of the Securities Exchange Act. We'll have joining us also by video, Professor Joel Seligman, who's co-author with Loss and Paredes of the premier securities regulation treatise, and Professor Christina Sautter, a nationally known expert who focuses on mergers and acquisitions and a professor at LSU. We provided further biographical information on our speakers in the materials and encourage you to look at those materials. I do want to mention that this program is being recorded and that it's been approved for CLE in the state of Texas. If you're looking for CLE for other states, we haven't specifically applied for that, but you could check with your jurisdiction to see if this would qualify. So please feel free to reach out. So without further ado, we're going to move into the meat of our conversation. Professor Steinberg will first present an overview of several of the positions in the book, and then we will proceed to hear from each of our panelists. Time permitting, after that, we'll take questions through the chat feature, which I will moderate with our panelists. So Professor Steinberg.
Thanks very much, Eric. I'm so thankful to be at SMU for my career and the support I get from this great law school. I'd like to thank Director Eric Hinton and Ms. Abrisha Culberson for putting this program together. And I especially want to thank the esteemed panelists. I'm just so honored that these four individuals have accepted the invitation to participate. After all, we have here the former SEC Chairman, Harvey Pitt, one of the renowned experts in securities law. We have Alan Dye, another renowned national expert. His short swing trading treatise is used throughout the country, the seminal work. We have Professor Christina Sautter, a very well-known M&A expert throughout the country. And then we have also Professor Joel Seligman, who's co-authored the seminal treatise with Professor Lewis Loss. I think the treatise is now up to 12 volumes in securities law. For those of you who are unfamiliar with the book, let me just read for a moment from the description of the book and exactly what the book attempts to do. This book focuses on a very timely and important subject that merits comprehensive analysis, rethinking the securities laws, with particular emphasis on the Securities Act and the Securities Exchange Act. The system of securities regulation that prevails today in the United States is one that has been formed through piecemeal federal legislation, Securities and Exchange Commission invocation of its administrative authority, and self-regulatory episodic action. As a consequence, the presence of consistent and logical regulation all too often is lacking. In both transactional and litigation settings, with frequency, mandates apply that are erratic and antithetical to sound public policy. The objective of the book is to identify the deficiencies that exist under the current regimen, address their failings, provide recommendations for rectifying these deficiencies, and set forth a thorough analysis for remediation in order to prescribe a consistent and sound securities law framework. By undertaking this challenge, this book provides an original and valuable resource for effectuating necessary law reform that should prove beneficial to the integrity of the U.S. capital markets, effective and fair government and private enforcement, and the enhancement of investor protection. The book focuses on several foundational topics. They include disclosure, exemptions from registration, both in the issuer and resale exemptive context, the Securities Act registration framework, the federalization of corporate governance, private securities litigation, insider trading, mergers and acquisitions, and the SEC itself. After I completed the book, I really wondered how many recommendations I made. A friend suggested that in the last chapter, I devote the last chapter to summarizing how many recommendations the book contains. My guess before doing that was that there was approximately 25 recommendations. Well, I certainly surprised myself because I believe there are 126 recommendations that are set forth in the final chapter. So let me highlight those that I think are the most appropriate for this type of discussion. The first deals with material information. In the European Union and many other developed markets, if information is material, it must be disclosed absent business justification otherwise. That is not our framework here. Here, of course, we have the SEC forms, the 10K, the 10Q, the 8K, the registration forms, and with narrative disclosure, the guidepost is Regulation SK. Simply put, if an item is not called for by an SEC form, and if the issuer has not spoken on this issue, generally there is no duty to disclose. As the courts, including the Supreme Court, have said on many occasions, there is no duty to disclose information simply because it is material. And the result is that we have a black hole in our disclosure framework. That information that is material, such as the loss of a major contract, does not have to be disclosed, for example, in a Form 8K. My recommendation is that we adopt the European Union framework, and that is if a business justification exists, then non-disclosure is permitted. Otherwise, if there's not a sufficient business justification, all material information must be expeditiously disclosed, generally within 1 business day. Second point is we have information overload today. The disclosure documents are getting longer and longer and longer. Obviously, institutional investors, other savvy investors have the time and energy and resources to devote to analyzing these documents. These documents are becoming more and more useless to the average ordinary investor. My recommendation is that in a 10K, in a proxy statement, in a registration statement, that a summary section be required to be set forth. So in other words, a summary section would have a 10-page limit where the registrant would be required to summarize the key contents of the document. I think that way the information would prove much more useful to the ordinary investor. Another point is incorporation by reference. When the SEC adopted incorporation by reference decades ago, the rationale was that these securities trade in an efficient market, and that information that was set forth in periodic reports, that information has been digested by the marketplace and absorbed into market price. Today, incorporation by reference is being used by companies that clearly do not trade in an efficient market. And the result, of course, is that this information is not being absorbed in the way that is required in order for incorporation by reference to be allowed. My recommendation is that a company can use incorporation by reference so long that it can establish under set criteria that its securities indeed trade in an efficient market. My next recommendation goes to the presence of a disclosure committee comprised of independent directors. This recommendation was made by an SEC advisory committee way back in the 1990s. I have tweaked it some, and my recommendation is that a disclosure committee comprised of independent directors who are required to retain their own independent counsel would be a requirement for an exchange-listed company. I think we all know that the outside directors have real issues with respect to access to information, that the insiders very much control this access, and also in the disclosure system, the process in which outside directors conduct their due diligence. I think the presence of a disclosure committee comprised entirely of outside directors who have their own legal counsel would very much enhance the corporate governance structure, enhance the ability of these outside directors to access internal information, and be overall a very positive development for the securities markets. My next point goes with the SEC with Regulation D. The SEC adopted the accredited investor definition in the early 1980s, except for Congress's tweaking of this a few years ago. The SEC has not changed this definition. Generally, one is an accredited investor if one has $1 million net worth, exclusive of one's primary residence. Through the years, the commission has refused to change this. And in the last commission, prior to the election, the commission made clear that its rationale for doing so was to change the accredited investor definition would be to impede capital raising. Well, I think we all know that a person who has $1 million in net worth exclusive of one's primary residence is not irrebutably presumed to be financially sophisticated and to have access to registration type information. This is simply an illusion that the commission has engaged in to enhance capital raising. As an agency in charge of investor protection, this is unsettling. At the very least, what the SEC can do is to index the $1 million amount that was adopted in 1982 to $2,022. So far, with this commission, we have seen proposals, of course, with ESG disclosure on this very foundational issue in which more and more money is going to the private markets than the public markets, where we have the dismantling of the mandatory disclosure framework with the use of Rule 506B, where somewhere around $1.5 trillion is raised annually pursuant to the 506B markets without any mandatory disclosure. This, in my view, is unsettling and unacceptable, and the commission needs to act. Thus far, it has not. Hopefully, it will in the near future. Let me bring up a more topical development, even so, in the papers in the last few days, and that's with respect to the application of Rule 15C211 to the fixed rate securities markets, and for example, Rule 144A offerings. What is not being discussed is simply the inadequacy of Rule 15C2-11. This is used by non-publicly held companies so that brokers, dealers can give quotes with respect to these not publicly traded securities in order to effectuate transactions. What is not being discussed is, number one, the dearth of information that is required by Rule 15C2-11, and even more so, that the SEC calls this information current. And how does the SEC define this information as current? That it's been within 12 months. And with respect to the balance sheet, that the balance sheet is within 16 months. It's sort of like, are you kidding me? Would any of us purchase a commodity in a privately held company where there's no transparency, where the disclosure you're getting is 11 months and 29 days old? I think the answer is rather clear. But yet the commission has continued to engage in this illusion that this is current information, and it's anything but current information. Let me talk about a couple items with corporate governance. One is that it should be required, as many other countries have required, that the CEO and the chair of the board of directors not be the same person. That, in other words, an independent director serve as the chair of the board. This, of course, would enhance the information flow when combined with the disclosure committee comprised of independent directors, would greatly improve, I think, the corporate governance structure and implementation in publicly held companies. Let me talk about compensation for a moment. I'm running through these. I'm going to try to hit the highlights here. This country has the greatest disparity of salary remuneration earned with respect to the CEO and the median worker. In this country, it's about 300 times to 1, more so than any other country in the world. How has it changed? 30 years ago, it was 61 to 1. So it's about multiplied fivefold in 3 decades. To me, this is something that ought to be changed. If congressional action is not appropriate, I have 2 other recommendations. One is that the shareholders say and pay vote, rather than being an advisory vote, become a binding vote. That the shareholders have a binding vote on shareholder pay. The second recommendation is that I think it would be quite a benefit for an employee representative to serve on the board of directors, and also for that individual to serve on the compensation committee. I think it may be an eye-opening exercise for those members who sit in the compensation committee when they receive the input from the employee who serves on the board with respect to the salaries and benefits that the median average worker pays. And does this CEO actually need $36 million rather than $15 million in compensation for the year? Let me talk about insider trading. Our insider trading framework is utterly unacceptable. We all know that. No other country in the world has adopted it. It's based upon fiduciary duty. The SEC tries to patch the loopholes through Rule 14E3, where one can go to prison if the transaction takes the form of a tender offer, but yet is able to legally keep his or her profits if the deal is structured as a merger. We have Rule 10b-5-2, which translates a non-disclosure agreement to a relationship of trust and confidence, which is simply a fiction. One engages in a non-disclosure agreement because he or she doesn't trust the party on the other side, but yet under this rule, one thereby assumes a relationship of trust and confidence. The answer is easy, and we go back to Texas Gulf Sulphur, and that this country should adopt the access or the period of information rule with respect to non-public information, and thereby join the ranks of other developed markets with respect to the insider trading laws. A controversial proposal I have, not to say that others are not, is with respect to Form 4. And that is, insiders, when they trade, they are required to file their Form 4 2 days after the trade. We all know that insiders have more information than anybody else. They may not technically have, quote, material information, but they certainly know what's happening with the company. They have far more valuable information than we do. My solution is simple, which of course insiders won't like, but my response is they're fiduciaries. And of course, the shareholders' interests should go before their own. And that is that the insiders must file, the directors and officers must file the Form 4 with the SEC before they trade. And then they must wait 1 business day, and they can trade their securities the next day. This gives shareholders notice that the insiders are going to buy or sell the securities, and puts the insiders at the back of the line rather than at the front of the queue. This is only fair and appropriate given the insiders' fiduciary duties to shareholders. And then let me talk about the SEC itself, just to wind up for a couple of minutes. And that is, the commission is simply not doing its job the way it should, in my view. One is that Congress in the Dodd-Frank Act directed the SEC to adopt many rules. To date, 12 years later, the commission still has not fully implemented this congressional directive. These were not requests from Congress, these were a directive, and here the commission 12 years later still has not adopted one. The recent pay versus performance disclosure rule was just recently adopted. The other points include, for example, the commission has taken away investor rights for no legitimate purpose. This is simply unbecoming of a regulatory agency that is in charge of investor protection. Let me give you two examples. One is that the commission sets forth a safe harbor from Section 10B liability with respect to specified items in the Form 8K where disclosure is not made. So in other words, with respect to certain items that are required to be disclosed in the 8K, if the company elects not to disclose those items, even if this non-disclosure is deliberate and made with fraud, investors have no remedy under Section 10B. To me, that's simply unacceptable. The other is the furnishing versus filing distinction, that one can furnish documents rather than file them and thereby avoid certain liabilities, such as Section 18A liability. And of course, this is done in order to protect insiders from what otherwise would be actionable conduct. Another point is the SEC's refusal to exercise in full vigor its enforcement authority. The SEC refuses to use the control person provision to charge CEOs, board chairs, CFO with control person liability. This provision, Section 20A of the Securities Exchange Act, is used with regularity in securities class actions by private litigators. It is used all the time, nearly 100% of the time. Yet the commission refuses to implement the control person provision during the financial crisis. Companies were paying billions of dollars of fines. And in the meantime, the SEC brought one enforcement action against a true insider, a CEO, and refused to use the control person provision under a Democratic administration. And what about the standards of conduct for attorneys rule? We all think we are very, very ethical lawyers, and I'm sure everyone on this program, everybody is ethical, but nonetheless, there are some unethical lawyers who do practice securities law. How many enforcement actions has the commission brought since it adopted the standards of conduct in 2003? The answer is zero, which just indicates that the commission is simply not using its enforcement authority. And then I talk about the SEC itself to conclude. People criticize the revolving door about SEC staffers going to the SEC and then getting these very attractive jobs in private practice, that somehow that should be changed. I'm not on board with that. I think the SEC needs a very good staff, and if you close those opportunities, then you're not going to get the quality of staff that you would like. My proposal, in fact, is a bit different, and that is the composition of the commission should be legislatively directed. The composition of the commission, although there are exceptions, has historically been rather one-sided, that the individuals come from large law firms, they come from private industry. Sometimes we have, the exceptions would be some academics and some capital staffers. For example, there's never, to my recollection, been a commissioner appointed who represents plaintiffs in securities litigation, although there are many fine securities law firms and experts conducting this type of work. So my proposal would be is that we would have commissioners selected from different type of backgrounds, a commissioner from a large law firm, a commissioner from an accounting firm, a commissioner who represents investors in securities class actions, one from academia or the government, one from an institutional investor which manages a public pension plan, one from a nonprofit organization whose membership invests in the securities markets, and one from an organization whose members are employees of publicly held corporations. I'll stop there. I again want to very much thank the Rowling Center and each of the panelists for being so gracious in honoring me and participating on this program.
Greetings from St. Louis. Marc Steinberg has been one of the most prolific and talented authors in corporate securities law for 2 generations now. Among his 40 or so books are 2 published by Oxford University Press in the past 4 years, The Federalization of Corporate Governance, and now Rethinking Securities Law. The 2 are linked. In The Federalization of Corporate Governance, Marc writes a detailed historical account of earlier efforts to create a comprehensive federal corporate law. He describes failed efforts early in the 20th century to adopt federal incorporation standards and the SEC's subsequent partial federalization of insider trading, corporate disclosure, specific proxy rules, board membership on audit committees and compensation committees, and other topics. The book is most striking for its concluding chapter, Unresolved Business, Federal Corporate Governance Enhancement. Rethinking Securities Law takes up where the federalization of corporate governance leaves off. It focuses on reforms to our current mixed system of federal and state corporate and securities law. Marc tilts towards federalization of this patchwork system. Let me comment on a few of the areas he addresses and place them in a broader context. Marc begins his substantive analysis with the argument that the federal securities disclosure regime should be premised on substantive fairness, not mandatory disclosure. Santa Fe versus Green is the paradigmatic case here, with its rejection of a definition of fraud to include traditional state law violations of fiduciary duty and limiting federal law essentially to material misrepresentations or omissions. While there have been instances where Congress has enacted federal fiduciary standards, such as the Investment Companies Act in part, or prohibitions on loans to corporate fiduciaries, Marc urges Congress and the SEC to engage in a more vigilant federalization of corporate governance, including full federalization of the validity of executive compensation arrangements. Marc concludes somewhat tentatively here, suggesting that this type of topic may be ripe for federalization during the next major financial catastrophe. Marc, all I can say is be careful what you wish for. This is a topic area that will draw critiques from both sides. To defenders of states' rights, substantive fairness would be a major incursion into the traditional state law role in corporate governance. To those who question the effectiveness of state law protection of shareholders in areas such as executive compensation or shareholder nomination of directors, the status quo can be criticized as fortifying virtually unassailable director business practices. Congressional and SEC efforts in areas such as these have been halfway houses. True, Congress has enacted say-on-pay provisions regarding executive compensation, but they're not binding. Former Proxy Rule 14A11 did provide for shareholder nomination of a minority of a board's directors, but was struck down by the DC Circuit as arbitrary and capricious because of its failure to effectively review the costs of this former rule. The SEC did not appeal or go to Congress. Marc here may well be on the right trajectory of where state law should go, federal securities law should go, but he is right that the politics of enactment of new far-reaching standards are the pivotal question. Similarly, Marc writes learnedly about several topics concerning the regulation SK mandatory disclosure system. He concludes by urging a mandatory requirement to disclose all material information. This would have the immediate benefit of supplanting the duty to disclose standard to invoke the Rule 10b-5 insider trading rules implicitly in favor of a universal true no trade rule until all material information is disclosed. These proposals are truly big deals and would achieve fundamental changes in our securities law system. Each is subject to a separate analysis. Mandatory disclosure of all material information is an argument that can be overblown. Regulation SK has focused on detailed, comprehensive disclosure items, recognizing that different industries and different stages of business firms and going public may have impact on whether markets already have, or companies have already communicated to the market material information, on some occasions through the efficient market hypothesis. These regulation SK standards are augmented by additional disclosure requirements for tender offers, securities exchanges, broker-dealers, investment companies, investment advisors, and others subject to SEC oversight, and go very far towards a mandatory comprehensive disclosure system. Should they be buttressed by a universal materiality standard? On several occasions, the Commission has explored doing so, most notably through the AA Summer Advisory Committee report in 1977. The Summer reports and other efforts were unable to achieve a simple formula. We now live with residual quantitative and qualitative standards in detailed Staff Accounting Bulletin number 99. I would urge that the underlying problem is less with Congress and the SEC and more with the Supreme Court decision in TSE v. Northway, which defined materiality, as subsequently further generalized, as omitted or misrepresented facts if there is a substantial likelihood that a reasonable shareholder would consider the information important in deciding whether to vote or buy or sell shares. This language has all been graven into the federal securities laws equivalent to the 11th commandment. The court itself recognized that it was rejecting alternative standards, such as information that might or would cause a shareholder to vote or buy or sell stock. This might standard itself could be combined with a quantitative test, such as one specifying that a fact or omitted fact is material if there is a 5% or 10% or 25% probability that would cause a shareholder to vote or buy or sell stock, what statisticians refer to as a confidence level. Marc's writing in this topic area deserves credit for potentially re-inviting debate over this debate type of idea. Marc's efforts to supplant the limit to insider trading liability to instances where an individual has a duty to disclose takes on a number of leading Supreme Court cases, including Chiarella, Dirks, and O'Hagan. This too has been a long debated topic, and the Supreme Court and the courts explicitly and Congress impliedly have rejected market egalitarianism, that is, the standard he wants on a regular basis. The Supreme Court achieved a broader ban on insider trading through O'Hagan's extension of liability to those who misappropriate information, whether or not they also have a classical duty to disclose. The Commission has taken a number of other steps, such as banning some forms of selective disclosure through regulation FD, or fair disclosure. A systematic ban on all trading while in possession of material non-public information is part of an ongoing debate. Would this make sense for the SEC or Congress to adopt or enact? Certainly, this case can be made that this will increase investor confidence in the market by those who would support this, and such a proposal would be opposed by those who see this as chilling some forms of analyst research and other legitimate business relations. I want to urge that there is an even greater basis for concern with an SEC rule adoption, given the current activist Supreme Court. Without a new congressional enactment, it is unlikely that the court, given past decisions, would defer to SEC power to interpret Section 10B of the Securities Exchange Act as a basis for a new far-reaching rule under the Chevron doctrine. Chevron is a general principle of deference to agency where a statute is ambiguous and administrative agency's interpretation is reasonable. Chevron has been under assault by the Supreme Court for a decade or so. In 2018, Justice Kennedy's valedictory opinion in Perea versus Sessions criticized what he termed as reflexive deference exhibited in earlier applications of Chevron. He strongly implied that Chevron should be supplanted under separation of powers principles and interpretation of statutes to preserve the function and province of the judiciary. The Supreme Court, in effect, in the West Virginia versus EPA case in 2022, and in other cases, declined to defer to the EPA interpretation of the Clean Air Act if the EPA could not show clear congressional authority for the power it claims in so-called extraordinary cases, when an agency seeks to exercise powers, quote, of vast economic and political significance. It is a safe bet that Rule 10b-5's insider trading rules would so qualify. Will Congress grant the Commission such authority? This is unclear and returns us to the political realm. The Commission historically has been reluctant to seek congressional enactment on politically charged topics. And what topic today is not politically charged, for fear that Congress will saddle the Commission with standards quite different from what it seeks. I lack the powers of Nostradamus, but this is not an idle concern, depending upon, for example, the November 2022 election results. Indeed, even when Congress does appear to grant the Commission powers to move on a specific topic area, such as shareholder nomination to corporate boards, litigants have other ways to challenge, such as the cost-benefit analysis or the arbitrary and capriciousness doctrines that's led to the striking down of former Rule 14a11 in the Business Roundtable case in 2011. Marc has provided us a roadmap to what will be viewed by many as a fairer or more investor-friendly future. For this, he should be applauded and grateful, and his scholarship lauded. As always, his analysis is thoughtful, detailed, and thorough. The challenge for Marc and others who seek to reform the securities laws, as he suggests in Rethinking Securities Law, may well prove not to be their wisdom, but the politics of Congress or the decisions of our courts. Marc, let me again congratulate you, and I hope this is a wonderful panel.
Good afternoon. I'm pleased to participate in this program and would like to thank the Rowling Center and Marc for including me in this important program. Professor Steinberg's book is a welcome reminder that our U.S. capital markets can be even more hospitable to investors. There is a need to reconsider old truths, and this book does that. So I think that this book will serve to prod debate and ultimately action in a number of areas. I have several observations to share. First, many of the areas that Marc has highlighted are already seeing renewed thought and debate. For example, the change in the composition of commissioners and senior officers at the Commission has undergone a significant change in the last year and a half with the new administration. There is definitely an effort to federalize corporate governance, which we're seeing take place in a number of areas. But I also think it's important to start with the points that Professor Seligman ended with, and that is case law like West Virginia, the EPA. The Chevron deference doctrine is under significant attack, as is much of what administrative agencies have been doing of late. I think that when one looks at the SEC today, one sees certain activities that appear, to me at least, to go beyond the traditional framework of SEC concerns, and certainly beyond the meat and potatoes segments that Marc Steinberg's book discusses. For example, the SEC's effort to require greenhouse gas emission disclosures on the part of public companies strikes me as the function of a different administrative agency, the EPA, but not the function of the SEC. And to see those types of efforts take place raises significant questions about, as I put it a moment ago, the meat and potatoes issues that the SEC has to address and should address. I think we are seeing, to some extent, an effort on the part of the Commission to reach a variety of areas and goals that are not within its initial framework and are not within its statutory framework, and will raise a significant question about the validity of rules that the SEC should, in fact, be undertaking right now for the protection of investors. To consider some of the specific proposals that Marc has listed, I don't agree necessarily with the notion that there be a change in the number of commissioners or the delineation of specific categories. My reason for concern here is I think the number of commissioners, 5, is adequate. I think that trying to compartmentalize commissioners can lead to difficult problems in governance for the agency. And indeed, we are now seeing more and more that members of the Commission are coming from Congress. And while I think the Commission benefits from having congressional representatives on the Commission, I also think a broader range of experience is required. Marc's suggestion about a business justification for non-disclosures raises a concern about when more may actually be less. I believe that there is an important requirement that material information be disclosed on a current basis. And indeed, we had proposed that when I chaired the Commission, and subsequent to my leaving the Commission has gone a long way in improving the reports required under Form 8K and requiring more current disclosure. I agree with Marc. I think a better job can be done of this. And I think the way in which this can be handled is with hyperlinks. I think Marc's notion of summaries is very important, provided that people are not concerned that they will be attacked because their summaries omitted certain types of information. The way to solve that is to adopt a venality standard. That is to say, current information should be disclosed in summary form, with hyperlinks for those investors that want to dig deeper into the information. This would prevent the non-disclosure of information, but it would also reduce the size of disclosure documents to a more manageable level, while providing those investors that seek more and more detailed information to be able to obtain that information. requirement of a disclosure committee could be very, very helpful, and many companies have adopted this, provided first that it does not slow down the process of obtaining more information. And second, that it has the resources to act promptly and quickly. With respect to corporate governance and the notion of a separate chair and CEO, I think having an absolute rule runs a risk. In some cases, having an independent chairman and a CEO will be a wonderful idea. In other cases, given the size of the corporation or the nature of its business, having that kind of dichotomy may be more cosmetic than actual. So I believe that it is important to allow flexibility with respect to whether companies engage in that, and have them disclose whether they do that, and disclose, if they don't do that, why they aren't doing that. With respect to insider trading, access to information and parity of information is difficult. The hard part for the commission is that it cannot be expected to look into the minds of individuals to figure out whether they used information or they merely had access to it. I do think a parity of access test may raise certain problems, but back in 1986, I believe it was, I led a committee in Congress that developed a statutory standard for insider trading. And I think reviewing those types of efforts in the past may give rise to a useful approach toward inside information. I do think that Mark's suggestion of requiring insiders to file trades that they make within 2 days is an excellent idea. We have reached the point where people can make filings promptly, and they ought to be required to do so. Let me end where I began and state that Mark's book is provocative. It is well-reasoned, it is thoroughly researched, and it is comprehensive. It deserves to be read by all of those who care about the federal securities laws, and it deserves to become the subject of constructive debate to try and develop a better system than the one we presently have. In sum, Mark, I think you've done a phenomenal job of raising important issues, and I'm very appreciative of the opportunity to be on this panel with you. Thank you.
Yes, let me begin by saying that I think all of us securities lawyers owe a deep debt of gratitude to Professor Steinberg for focusing all of us on the big picture of securities regulation, particularly with the big ideas that he's expressed in his most recent book. And I think revisiting securities regulation comprehensively, as Professor Steinberg suggests, is a worthwhile effort, despite the time and effort it would consume to see through many of the ideas that he recommends in his book, but it's certainly worth beginning a dialogue. And I want to thank Professor Steinberg and the Rowling Center for allowing me to participate in today's program and be part of that dialogue. I'd like to focus my remarks on Professor Steinberg's thoughts regarding insider trading. And if we have time, offer a few of my own. I will assume that most people agree that allowing insiders to trade on material non-public information to the detriment of uninformed investors is an undesirable result, despite some of the thoughtful works of Henry Manny and other Chicago schoolers many years ago, which I think had a lot of merit. But I think the prevailing view is, and it's certainly mine, is that allowing insiders to trade on the basis of material non-public information they've obtained as fiduciaries of the corporation would severely undermine the integrity of our capital markets. I mean, as an initial matter, I think it's just generally unfair for someone to trade with that advantage, but the effect on the capital markets could be significant if ordinary investors, as I'll call those who are less informed than insiders, know that the deck is stacked against them when they trade in the public securities markets. And ultimately, I think that the ordinary investor would withdraw from the game knowing that the deck is stacked against him or her, and that would significantly weaken our capital markets. So it's significant to have an insider trading scheme that does, what I think, three things. One, it clearly prohibits insider trading, clearly and appropriately defines what constitutes insider trading, and third, establishes appropriate mechanisms for sanctioning those who violate the prohibition. Now, as Professor Steinberg mentioned in his opening remarks, I'll try to be brief given that he's already covered the point well. Insider trading today is governed primarily by, or sanctioned primarily by Rule 10b-5-1. I'm sorry, by Rule 10b-5. And it was first invoked to address insider trading, as Professor Steinberg noted, in an SEC enforcement action in 1961. The same theory was accepted by the courts. And since then, Rule 10b-5 has been the primary weapon for addressing insider trading. But the courts and the SEC haven't always treated Rule 10b-5 prohibition in the same way. Now, both then and now have generally treated Rule 10b-5-1 and insider trading as being based on a form of fraud. Generally saying that if an insider is in possession of material non-public information, he has a fiduciary duty not to trade on the basis of that information to the detriment of the less informed investor. And in addition to that classical theory of insider trading is the misappropriation theory, on which an outsider of the corporation is prohibited from trading on the basis of information that's been obtained about the company based on a contractual or other obligation not to trade imposed by, for example, the trader's employer, or by a contractual arrangement between that employer and the issuer of the security. And as Professor Steinberg points out, both theories arguably suffer from underpinnings that are rooted in breach of a duty, with the result being that, for example, an insider of a company who tips a third party but receives no personal benefit may not have violated Rule 10b-5, and the trader is free to trade on the basis of that information. Similarly, in a misappropriation type of case, someone who obtains access to material non-public information may not breach a contractual duty if the employer or the company, based on its relationship with the employer, doesn't impose a contractual duty of confidentiality or a duty not to trade. And those results, I think, to many are undesirable in a perfect world of regulating insider trading. And so I'll address what I think could be an appropriate way of addressing insider trading. I mean, we're thinking big thoughts here, and I'm thinking about the big thoughts that Professor Steinberg has offered. And it does strike me that it would be possible, maybe as Joel Seligman was suggesting, it would take congressional action and not SEC action, But it would be possible to revisit the rules of insider trading and in some manner eliminate the duty requirements and impose something along the lines of a parity of information requirement, as Professor Steinberg suggests. I'm not familiar with the legislation that Harvey Pitt mentioned having seen at least some bit of daylight some years ago, but it strikes me that it's conceivable that a regulation or a statute could be adopted that would impose a parity of information requirement, subject obviously to exceptions. I mean, it strikes me that given the number of legitimate ways in which people who become investors come into possession of a superior level of information relative to ordinary investors in the market, suggests that any parity of information requirement would have to be drafted in such a way as to either specify the circumstances in which trading on that superior information would be considered unlawful, or stated another way, it would need to prohibit trading on the basis of superior or material non-public information subject to appropriate exceptions. Now, those circumstances wouldn't necessarily need to be based on fiduciary duties or contractual duties, but on policy judgments based on such things as the source of the information or the manner in which the trader obtained it. Now, without a doubt, drafting that rule would be challenging and would involve a number of policy trade-offs, but it seems to me that it could be done. In fact, I think it conceivably could be done in a way that addresses other areas that are in the news today that present issues of insider trading. I think it was just this week, maybe it was last week, that legislation was introduced in the House to address, I think actually was to prohibit trading in public company securities by any member of Congress. But there's a broader range of conduct that I think could be subsumed within a regulatory scheme administered by the SEC that addresses the circumstances in which people who come into possession of information that gives them an advantage in the market could be prohibited or otherwise regulated. Let me mention briefly the concept of materiality. As Professor Steinberg recommends in the book, it's a good idea to have a definition of materiality and to have that definition of materiality applied uniformly, whether it's the company making a decision about the materiality of information for inclusion in an 8K or its 34 Act reports, or in determining whether the company will open the trading window for its insiders and allow them to trade in the market. But a clear and single definition of materiality, which could be based on, as Professor Steinberg suggests, impact of information on stock price, significance of the information to investor or a reasonable investor. I think a number of different standards could be brought to bear, but a clear definition of materiality would also be, I think, a welcome addition to a regulatory scheme addressing insider trading. Now, apart from the insider trading rule changes that have been suggested by Professor Steinberg, Professor Steinberg recommends, as he mentioned in his opening remarks, and as were alluded to by Harvey, changes to the disclosure system that would, in effect, limit the shelf life of material non-public information, and by limiting the shelf life, limit the opportunities for insiders to trade while in possession of material non-public information. You know, under the SEC's current regulatory scheme, a lot of information isn't disclosable until either the company's next periodic report or in certain circumstances on a Form 8K. And Professor Steinberg has recommended that, and I divide this into 4 parts, Mark, and I hope you would agree that this is accurate. First, require companies to disclose all material information, not just information mandated by the SEC's rules or regulation SK. Second, require that disclosure, when new material information arises, be made by the company within 1 business day. 3, ban trading by insiders prior to the public disclosure of that information. And then 4th, require insiders to file a public notice, which you mentioned, Mark, would be on a Form 4, of their intention to trade before they actually trade. All of those suggestions, I believe, have merit and are worthy of discussion. Some would require some difficult judgments, I believe, particularly the time within which public companies would have to make a determination that information that's developed or come to the company's attention is material and draft a disclosure form to do that. But from an insider trading standpoint, that would be easy to administer because I think most companies under their insider trading policies have a pre-clearance policy that requires insiders to pre-clear their trades before they actually place an order with a broker. And in cases of doubt or close cases or time is required to make a judgment about the materiality of information, I think most companies would err on the side of caution and prohibit their insiders from trading until a determination has been made. And if the information is material, then they would make the disclosure. One issue I have some difficulty with is the suggestion that companies disclose all material information, not necessarily because it's mandated by an SEC rule or the SEC rules that say that any disclosures that have been made need to be accompanied by additional disclosures if necessary to make those required disclosures not misleading. The range of items, information, developments, subjects that might be deemed material can present challenges when sitting in a room with officers and directors and trying to determine what disclosures are required. The benefit of the current system, in my opinion, and I'm not advocating for it, but the benefit of the current system is that it focuses companies on what has to be disclosed. There's an SEC rule, and then once those disclosures have been drafted, the process can be undertaken to determine whether more should be said to make sure that what's been disclosed is clear. To untether the disclosure requirement from any specified SEC rule to me can be somewhat problematic. I can think of times when I was teaching law school at Georgetown, and we'd ask members of the class, I was co-teaching it, and we would ask members of the class, well, do you think this information is material? And half the class would raise its hand and the other half wouldn't. And so, and they were items that were not addressed by the SEC's disclosure requirements. And so I think it can be a challenge to impose on companies an obligation to do that. I'm not familiar with the securities laws of Europe that you referred to, Mark. And if that's the system they use and it's been working over there, then it's certainly something worth revisiting. It's just an issue that I believe would need to be given some thought and scrutiny before we're implemented. And let me close by offering one final thought, and I'd like to address Section 16B's place in the regulation of insider trading. Now, Section 16B is an unusual statutory provision in that it prohibits nothing, and the SEC has no jurisdiction to enforce it. Only the company or security holder of the company can bring an action to enforce it. And the only sanction is that the insider has to disgorge or pay to the company any profit realized upon the short swing trade. And while purportedly it's an insider trading statute, there's no requirement that the insider have traded in possession of material non-public information on either the purchase side of the short swing trade or the sale side of the short swing trade. Professor Steinberg recommends that Section 16B be repealed for the reason that it's lost its vigor due largely to the SEC's adoption of exemptions from Section 16B that effectively vitiate its application in circumstances where, at least in Professor Steinberg's view, its application is most warranted and where there's the greatest opportunity perhaps for an insider to trade on the basis of material non-public information. And while I don't quarrel with Professor Steinberg's reading of those exemptions, I don't think it's necessarily true that Section 16B should be repealed because the SEC has gutted it to the point where it doesn't have adequate or appropriate application. But calls for repeal of Section 16B are not new. It seems that every 10 years or so, there are calls from one group or another for the repeal of Section 16B. And the usual reason asserted for repealing Section 16B is that Rule 10b5-1 addresses real insider trading, requires a showing of trading on the basis of material non-public information. So why is there a need for Section 16B, given the development of Rule 10b5-1 as the primary weapon against insider trading? It's, in my experience, not a common argument that the statute should be repealed because the SEC isn't effectively adopting or narrowing its exemptive rules to permit the statute to apply. But in any case, I think it's a worthy conversation to have, whether Section 16B still has a role in policing insider trading. I will say that in the years that I have spent with Section 16B, both in writing about it and in practicing under it, have seen some benefits to Section 16B. And not the least of which is insiders who know that they can't sell their stock if they've just purchased it until 6 months have passed, or can't buy stock if they've sold it. Maybe I've reversed those two, but they can't have both a buy and a sell within 6 months. It certainly takes their minds off of daily movements in the stock price or day trading in their own securities, which I think would be a temptation for many insiders and a distraction for some of them as well. But I do agree that there are many things about the rules under Section 16B that could be improved. The SEC hasn't comprehensively reviewed the Section 16 rules since 1991, and perhaps they are overdue for changes. And I certainly have my own personal wish list of things that I think could be done to improve the application of Section 16. But repeal, again, an issue worth discussing, but I think it's going to require a fair amount of discussion before, I, for one, believe that it necessarily needs to be repealed or warrants repeal. So that concludes my remarks. I'd again like to congratulate Professor Steinberg on yet another wonderful contribution to big thinking about the application of the federal securities laws and how they might be improved. And again, I thank him and the Rowling Center for allowing me to participate in this dialogue.
Good afternoon. Thank you so much to Mark and to the SMU Rowling Center for inviting me here today. It was certainly a pleasure to read Mark's latest book, and I can definitely see why it is an award-winning book. So I'm honored to be here virtually to comment on it. I'd like to recommend Mark's book as an excellent resource for very accessible descriptions of extremely complex areas of the law. The book is treatise-like without being overwhelming, and I think it's a very interesting read. At the same time, though, as the other panelists have alluded to, Mark has engaged in a very masterful execution of not only describing both the strengths and the weaknesses of our current securities law framework, but also provides very innovative recommendations for bettering securities laws. So I'm going to make a few comments, mainly focusing on the M&A aspects of the book. And at the end, time permitting, I'll make a comment or two about retail investors. So Mark includes 7 numbered recommendations for reform in the M&A section. And if you are lucky to have the book and you're following along, it starts on page 251. And I, for the most part, wholeheartedly support these recommendations that Mark is making. The first big recommendation is with respect to the amendment to Section 13D, the beneficial ownership and disclosure section, which is always a hot button issue. So as we know, the current law provides that any person or group of people, when they're acquiring more than 5% beneficial ownership of an equity security of a publicly traded company, must make disclosure within 10 days with respect to the ownership and with respect to what they're going to do with that ownership of those securities. So there's many issues with respect to the ownership threshold and with the 10-day period. Namely, one of the biggest issues is that people can continue to build up their ownership stake during the 10-day period. And as we've obviously most recently seen and famously seen with Elon Musk and Twitter, of course, there's other issues with that example as well. So Marc's solution is to decrease the ownership threshold to 3%, so from 5% to 3%, and to file disclosure within 24 hours of exceeding the 3% threshold. So not 10 days. This is a significant change. And one further recommendation that Marc makes is that these individuals are required to wait at least one business day before making more purchases. I really like this recommendation. I think that it reflects our modern markets. I think it reflects the rapid incorporation of information that we now see. And as Marc describes in the book, if someone is taking a 3% ownership stake in a company, that is certainly material information that reasonable investors would want to know now as soon as possible, not 10 days from now. So I'm not going to go through in as much detail the other remaining 6 recommendations, but I do want to highlight several of them, which I believe has a common thread. So these recommendations are a mandatory binding shareholder vote on the adoption of golden parachutes, which is recommendation number 2, a mandatory binding shareholder vote if a company is paying green mail, which is recommendation number 3, and requiring a shareholder vote when a company is adopting defensive measures to ward off hostile takeovers. This is recommendation number 7. So this would include a vote for things like adopting a poison pill or a recapitalization plan. And it also even extends to the adoption of lockups that are being entered into with friendly bidders in a negotiated transaction. I really like this recommendation as I have been critical in my scholarship of the UNICAL Enhanced Scrutiny Standard, and in particular the Delaware court's application of the UNICAL Enhanced Scrutiny Standard, that in application, the Delaware courts are not really treating the UNICAL Enhanced Scrutiny Standard as an enhanced scrutiny standard, but rather they tend to treat it more as a hands-off business judgment rule. So I really like this recommendation. And then the final recommendation I wanted to focus in on is requiring a vote of the shareholders of an ultimate parent company in a triangular merger, and also in a tender offer. And this is recommendation number 4. So I wanted to take a minute to discuss this particular recommendation. And a reminder to those of us who may not be practicing M&A on a daily basis, but when we're talking about triangular transactions, what we're talking about is a situation where we have an acquiring company who is forming typically a wholly owned subsidiary to be used as an acquisition vehicle to merge with the target company. Now, this is far and away the most popular form of a transaction structure for a number of reasons, but one of the reasons is because the ultimate acquiring parent company, the acquiring company shareholders, do not have a right to vote in this particular transaction. In addition, with respect to tender offers, the bidding company in a tender offer, their shareholders do not have the right to vote either. So I should say that this is something that I always take for granted, but every time I teach mergers and acquisitions, which is every fall, and I'm reminded about the kind of lack of shareholder vote with respect to the acquiring companies in these two different scenarios. I just taught transaction structures in M&A a couple weeks ago, and I was reminded yet again of the potential unfairness of this system to acquiring shareholders. Every year, it's very difficult for my students to conceptually understand that the board of directors of the acquirer in this scenario has essentially a complete say in this area, and that the shareholders are, in essence, disenfranchised. And really, their only remedy is to do the Wall Street walk and sell their shares. So the recommendation by Marc to have a shareholder vote for the ultimate acquirer, particularly in triangular transactions, is a significant game changer. And it would have a significant impact on M&A deals well into the future. So these recommendations that I've mentioned really speak to me. Throughout my academic career, I've written extensively in the M&A field, largely focusing on deal terms like lockups and fiduciary duties. And more recently, my scholarship has been focused on retail investors and on corporate governance. And the underlying thread through all of my scholarship has been to empower shareholders, to treat shareholders fairly, and to provide shareholders with a voice. So I really like the idea, and I'm drawn to the idea of giving shareholders a voice and a vote. I do, though, have some concerns with the feasibility of adopting some of these recommendations and the pushback that is likely to be received. So obviously, in the context of requiring a vote of the ultimate parent company shareholders in a triangular transaction is going to cause transactions to be more expensive. There's a possibility, of course, that shareholders will reject the transactions and also will slow or could slow the transactions down. Along these same lines, I'd also like more information on logistically how the vote would work in the context of a tender offer. Because as we all know, tender offers tend to be much faster transactions, and significantly because we don't have to call and hold a shareholder meeting. So Marc, if you have time to speak to that, I'd love to hear your thoughts on the logistics of the vote in the tender offer context. And then speaking of voting, I wanted to just mention one or two words about voting and retail investors. Particularly with the recent influx of more retail investors, and particularly from younger generations, I think that we need to make voting easier for retail investors so that the recommendations that Marc suggests, particularly with respect to the M&A recommendations he suggests, can be adopted and can be effective. One final comment relating to retail investors. I really like the summary section recommendation that Marc discussed and that Harvey also mentioned. I think that this is sorely needed, but I think that we need to go a little bit further here. I'd like to see the summaries that Marc recommends, the summaries of each company's disclosure being gathered in one place, and maybe even outside of the EDGAR system, where they can be more easily accessed by the ordinary investor. So studies have found and have shown that for the most part, investors, particularly retail investors, do not download and do not read disclosure. And I also do not think that most individual ordinary investors understand EDGAR, understand how to use EDGAR, how to access EDGAR. And we also definitely know that new generations of retail investors are getting their information not through the SEC's website, not through EDGAR, but rather through other websites and social media, which is another huge cause for concern. So I think the summaries are a great start, but I think that we need to think about ways to make these most accessible to retail investors who are the most likely going to be reading them and relying upon them. So Marc, many kudos to you for writing this fantastic book that focuses on investor protection and investor engagement. And thank you again for having me comment on your book.
Thank you so much, Professor Sautter. And we'll ask our panelists to join us just for the conclusion. While we're doing that, Professor Steinberg, would you like to make any comments to some of the points made or questions asked before we go to our remaining time?
Well, I'd like to thank each of the panelists for their kindness. Very, very kind of you to say nice things about the book and about me. I'm very appreciative. And it's amazing that each of you do not agree with me on every single issue. But I appreciate your disagreement and with the way that that you provided it, and I'm very thankful you're here. Thank you.
Great. We have a few questions a number of questions, and I'm going to go through them maybe selectively and ask them to our panelists. One of the questions relates to the independent director disclosure committees, and the crux of the question, Professor Steinberg and others, is how would you actually operate those efficiently given the constraints and difficulties it is to operate a board?
I suppose I'll just jump in first, and my analogy would be to the audit committee. And that is that this would be a counterpart to the audit committee. The audit committee, of course, is comprised entirely of independent directors. Audit committee can hire and retain its own legal counsel and has a set schedule quarterly with respect to looking at issues that are within the spectrum of the audit committee. So my proposal would include using the audit committee as a base and having the disclosure committee operate in a similar manner.
Any other comments for other panelists? All right, let me ask you this one then. How would you view the alternative of a lead independent director in lieu of an independent board chair? This has been discussed in the context of RICs. Anyone want to take that one?
Well, I guess I'll take that one first, since and that is I've seen them in operation through my consulting and expert witness practice, and my view is that as a generality, there are exceptions that a lead director is a meaningful development, but I don't think that lead director generally takes the activist role that an independent chair does. And I do think that Harvey has an excellent point, and that is with respect to these, as Harvey usually does, perhaps always does, is that with these smaller publicly held companies, they are at stress getting independent directors in the first place. And for them to be able to get an independent chair to take on those obligations would make this situation even more onerous for them. So I understand the concern when you have the smaller publicly held corporations, but yet the argument the other way is with these types of companies, perhaps the need for independent chair is even more so, because there is less of a corporate governance framework that has been developed in those types of companies.
So there are two questions, and I'm trying to decide which one to go with first that are different maybe than what we focused on. I'll go with this one. The first one is that it seems to me that the elephant in the room is that the markets for raising capital are in private equity versus public markets, basically, and that this has probably contributed to the decoupling of price from performance in public companies as a growing pool of investors chase returns in public markets and exclude many emerging companies. So the benefits of going public are outweighed by the costs. So do you want to kind of give your thoughts as to that dynamic, whether you agree with the questioner's proposition and what you think can be done?
I guess I'll just lead off again, and that is it's clear that's happening. There's the dismantling of the mandatory disclosure framework with Rule 506B1 Rule 506B, that the amount of capital being raised in the 506B market far exceeds that in the public market. The SEC, through its activism in other areas during this administration, has declined to address this issue in a meaningful way. And Congress has declined to address this in a meaningful way with respect to that a company doesn't have to be a publicly held company unless it reaches a certain number with respect to shareholders of record. And rather than using the beneficial ownership criteria, which is used under other statutes such as Section 13D and Section 16, Congress has the shareholder of record situation, which permits these very, very valuable companies, these unicorns, having over $1 billion of assets to remain private, with minimal disclosure being in the public markets.
All right, last one's a huge question and we have 2 minutes, but we'll give you a chance. So what are your thoughts about the proposed climate disclosure proposal and how it fits within the SEC's mission to protect investors, et cetera?
I don't want to go first this time. I've gone first.
Well,
Thank you.
I addressed this briefly. I think that the SEC has the ability to require meaningful disclosures about changes in the climate, and the fact that the Biden administration has made climate control such a major issue means that its relevance for public companies becomes more important. I think the SEC has usurped, if you will, the functions of the EPA in terms of dictating greenhouse gas emission disclosures by companies. And I worry that that will create problems for the SEC, not just with these rules, but with rules that are clearly needed and that are included within the things that Marc has identified. So my view is there is a sound basis for the SEC to require, for example, investment funds that are claiming to be ESG pro formas to back that up. And if they can't do that, then they should be prevented from trying to sell a product they're not offering. But with respect to the greenhouse gas emissions, I think that's a job the SEC should leave to the agency Congress designated.
Thank you so much. I think, go ahead, Marc, would you like to?
I'll just jump in with this comment, and that is, I largely agree with Harvey. My concern is that the SEC has a host of other issues, as Harvey has pointed out, that far more directly impact investors. For example, the accredited investor definition would be a huge example. And a lot of these issues, the SEC is not being active on. I think it's far more important that the SEC focuses on those issues that impact investors in a much more important way than with respect to ESG disclosure, where I agree with Harvey that the Environmental Protection Agency is the agency that is principally charged with this mission.
Excellent. Well, I see that we're at the end of our time. Unfortunately, we can't go further, but I'm sure this discussion will go on for a while. And we hope, Professor Steinberg, that many, if not all of your proposals see a hearing and possibly are implemented. So stay tuned. Maybe we'll do a reprise later on. So thank you very much, Mr. Pitt, Mr. Dye, Professor Sautter and Seligman, and especially Professor Steinberg. We thank all of our participants. We hope that you found this exciting and interesting, and look forward to having you back again for another discussion. Have a good afternoon. Thank you.
Thank you.